Hello and welcome back to our special lecture series. My name is Taimur Khan and I'm an attorney at law. Today we are going to cover yet another important constitutional case, the famous Begum Nusrat Bhutto case. But like as always, before getting to this case, I'm going to very quickly give a rundown of the important turn of events which happened in the wake of the famous Asma Jilani judgment up to the events that led to the passing of the current case that we are going to discuss. Now, the important highlight of the Asma Jilani judgment was that proclamation of martial law by itself does not involve the abrogation of the Constitution, and in terms of doctrine of necessity which was pressed in service, Chief Justice Hamoodur Rahman eloquently said that this doctrine can only be pressed in service once the actions of the usurper have been declared as illegal and illegitimate, and only after the court has come to this conclusion can the question arise as to how many of his executive acts should be condoned, keeping in view the wider public interest. Now, coming back to the respective events, in the year 1972, the famous interim constitution came into effect by the 21st of April 1972. This was a sort of a provisional constitution till such time that the constitution which was being debated would come into effect, which was the 1973 constitution, which was ratified and came into effect on the 14th of August 1973. Now, interestingly, no fresh elections were held in Pakistan after this constitution came into effect, something which was rather different from how things happened in Bangladesh. After the 1972 constitution came into effect, their fresh elections were held, where Mujibur Rahman again won. However, here the fresh elections were held in the year 1977. But before that, just 1 year before, two very critical, I would say, and special amendments were carried through, which were incorporated in the Constitution, the 5th and the 6th Amendment, which are really very important for all constitutional students. You see, in the year 1976, Chief Justice Sardar Iqbal was sitting as the Chief Justice, and the senior puisne judge then at the Lahore High Court was Maulvi Mushtaq Hussain. These two judges never got along. Now, there was somewhat of a problem that Chief Justice Sardar Iqbal, when the call came to be elevated to the Supreme Court, he simply refused. He said that this is a far better position than becoming an Associate Justice of the Supreme Court. And the senior puisne judge, Maulvi Mushtaq Hussain, who had set his eyes on the post of Chief Justice, also refused. And so many of the judges junior to them had been elevated, whereas these two judges were not budging in. So the 5th Amendment was passed, which said that unless you are Chief Justice of the Supreme Court and you have reached the age of retirement at 65, then you will continue for a term of 5 years. And whereas for Chief Justice Lahore High Court, if you have completed your term as the Lahore High Court Chief Justice, then either, unless you are elevated, you will either retire or become the senior most judge. However, there was another problem that had come across with Zulfikar Ali Bhutto. Chief Justice Yaqub Ali, who got along just well with Zulfikar Ali Bhutto, was due to retire, and so since 1977 was the election year, constitutional amendment was passed, the 6th Amendment, just to save him from retirement, which said that notwithstanding somewhat the 5th Amendment or the effect of the 5th Amendment, even if you have reached the age of retirement yet you have not completed your term for 5 years, then you will continue to retain his office, and that is why Chief Justice Yaqub Ali managed to stay in power as the Chief Justice. So coming back to the elections, which were held on the 7th of March 1977 for the National Assembly and 10th of March for the Provincial Assembly elections, the Pakistan People's Party managed to secure some 155 seats out of 200 seats. They bagged 4/5 of the total vote, whereas the Pakistan National Alliance PNA, a name which was given to the combined opposition that wanted to take on Pakistan People's Party, only managed to secure 1/5 of the total vote. And right after the announcement of the results in the elections, there was countrywide protests which were being staged all across Pakistan. The demands were that Zulfikar Ali Bhutto must resign, the Chief Election Commissioner must resign, fresh elections must be held. Initially, Zulfikar Ali Bhutto didn't agree to these demands, and he even went to the extent of having a 7th Amendment passed by the Parliament, which said that there would be a referendum, but unlike the previous referendums where the stamp of validation is taken from the public, the stamp of validation would come from the parliamentarians. However, This never got to the vote, as a few months before PNA and PPP again came across the table. They wanted to discuss certain terms, and by 3rd of June 1977 there was some form of an understanding that talks had commenced, and by the 15th and 16th June it had materialized further that there will be an accord which would be signed by PNA. By the 2nd and 3rd July again there was somewhat of an impasse. There were some new demands being made by the Pakistan National Alliance. However, as pointed out by certain historians, on the 4th of July by night time, Zulfikar Ali Bhutto had signified his intention that he was due to sign the accords in the morning of the 5th of July. But before that, the night before, in between 4th July and 5th July, General Ziaul Haq struck. And so he issued a proclamation of martial law, whereby the 1973 constitution was suspended. It wasn't abrogated. The national as well as the provincial assemblies were dissolved. The provincial national cabinet were dismissed. A new martial law order had somewhat been issued. And so in the backdrop of these events, this famous Begum Nusrat Bhutto case takes place. Briefly, the facts of this case were that by the 17th of September 1977, Zulfikar Ali Bhutto was arrested with 10 other leaders of the leadership, and they were all detained under this new martial law order number 12, which had been issued under the Laws Continuance in Force order of 1977. And as historians point out, that by July, General Zia had intended that new elections would be held by October, and then all political parties would be allowed. But there was a famous 15 July treason talk incident, where this talk of treason somewhat have given chills to General Zia, that he was a usurper and that he could be tried under Article 6 for treason. And this is the point when he thought otherwise, given how many large crowds were gathering up to see Zulfikar Ali Bhutto, that something had to be done. So when Zulfikar Ali Bhutto along with other leaders were detained and they were being held in different prisons, Begum Nusrat Bhutto, who was the wife of Zulfikar Ali Bhutto, filed a petition under Article 184(3) of the present 1973 Constitution. And the claims that she had made, as were enunciated by Yahya Bakhtiar, who was serving as the counsel, were that General Zia had no authority under the Constitution to promulgate a martial law and to suspend the Constitution, and even if somehow it could be condoned on the basic principle of doctrine of necessity, the detention orders were all illegal because they were downright discriminatory. That only the PPP leadership had been arrested, whereas the leaders from PNA had as such not been arrested. And Yahya Bakhtiar alleged that fundamental rights had been breached, namely Article 9, that no person shall be deprived of life or liberty save in accordance with law, Article 10 dealing with the preventive detention, Article 17 right of association, as well as Article 25 that there is discrimination, and so on. So initially certain preliminary objections were raised from the government side. They said that this petition as such is directed against the Chief of Army Staff, whereas the detention orders have been made by the Chief Martial Law Administrator, and that Begum Nusrat Bhutto as such is not an aggrieved person. Since the jurisprudence, since the Constitution had only recently been promulgated, there wasn't so much of jurisprudence in terms of what the mandate of Article 184(3) was, which is why this objection was taken. However, the court ultimately held that this is more of a technical objection, that this was directed against Chief of Army Staff, not the CMLA. This can be corrected right away. And the fact of the matter is that Begum Nusrat Bhutto is the wife as well as acting chairman, so she very much is an aggrieved person, and even otherwise relying on Manzoor-ul-Lai, which was probably the first case under Article 184(3), which somewhat said to the effect that the trappings of Article 199 would not be very much attracted. Article 184(3) has its somewhat different source. Now coming to the merits of this case, Counsel A.K. Broi and Sharifuddin Pirzada, who had served as amicus in the Asma Jilani case, were now also part of this case. Sharifuddin Pirzada was the Attorney General, whereas A.K. Broi was the counsel for the respondent. And interestingly, they again had to revisit what they had pleaded in the Asma Jilani case. Sharifuddin Pirzada remained consistent with his earlier version. He didn't support the Hen-Kelsen theory, whereas A.K. Broi took up that Hen-Kelsen theory would very much apply, that initially in State versus Dosso it was given validation, in Asma Jilani it was not. Maybe a middle way ground somewhat has to be reached. and that he said that up to 5th July, Zulfikar Ali Bhutto's government can be classified as different, and after it was downright illegal, and given the allegations which had been made. And so he also pointed out on certain figures that Chief Election Commissioner himself had admitted that many of the election results were affected, that out of the 26 seats, 6 seats had simply been notified as not having been acquired correctly, and there were also many other seats now which were being called into play. However, long story short, on the point of Henn-Kelson's theory, given what was already discussed and was already held in Asma Jilani case, that this is a pure theory of law which is based on normative norms, it is just a jurist proposition, the very efficacy of change, and the basic principles of Henn-Kelson's, as had been established, as had been held in Asma Jilani, would very much apply, and the theory of revolutionary legality as such cannot be given effect to. There was a very famous case, the Rhodesian case, that was relied upon by the government side. They said that there was Ian Smith, and he had given his own new constitution in 1965, which was to set aside the 1961 constitution, and the courts said, because it had made its way to different forms, the courts came up with the point of view that a de facto leader would be considered as a de jure leader, and so any detention orders, if have been issued, would be considered for the short time that they had been in effect. However, this judgment failed to distinguish in between the acts of a usurper and someone who has taken over the reins, as was pointed out by the Privy Council. So this judgment really didn't have that much of an effect. Long story short, on the point of Henn-Kelson's theory, the court again relied upon its earlier holding given in the Asma Jilani case. The first hearing of this famous case took place on the 20th of September. At that time, Chief Justice Yaqub Ali was still the presiding Chief Justice. However, as on 20th September this petition was admitted, General Zia somewhat got the chills, and on 22nd of September, through a CMLA, Chief Martial Law Order, which was promulgated, the effect of the 5th and 6th Amendment was taken away, because of which Yaqub Ali had to resign, because he had already reached the age of his retirement, and his place, Justice Anwarul Haq, was then the Chief Justice to ultimately decide this famous case. Another interesting thing about this Begum Nusrat Bhutto case was that, unlike the other martial laws, the continuing existing President Chaudhry Fazl Allahi was allowed to continue to serve as president, and as such the office of president was not dismissed, which was very interesting. So now, when the question of doctrine of necessity came to be questioned, came to be debated, the court firstly took back to the Governor General case. This is the first time in the constitutional history that the doctrine of necessity was pressed in service, and the paragraphs were rather reiterated the famous address of Lord Mansfield, that if an action otherwise which is illegal would become legal if it is done under the stress of necessity, the necessity being referable to the intention to preserve the Constitution and to avoid the breakdown of the constitutional machinery. And again, this doctrine was pressed in service in the Asma Jilani case. However, the courts came to the conclusion that only once you have concluded that the acts of the usurper were illegal and illegitimate, only then the question rises as to what should be condoned and so forth. So here now the counsels for the respondents went through and talked about what happened on the 7th of March 1977, when afterwards the Chief Election Commissioner in an interview admitted that as much as 50% of the overall results were affected. And because of massive alleged rigging and the use of state machinery, countrywide protests had taken place. 241 civilians had lost their lives, more than 1,000 people were injured. The country was nearing a standstill. And so what happened on the 4th July and the 5th July, or the time in between, was that PNA was still not budging in, and it appeared that PNA was about to again go on and launch massive agitation movements all across the country, which the country was just not ready to handle. And another important argument made by the government side was that this measure which has been undertaken by General Zia is for a temporary period. That General Zia has no plans, no ambition to take on and to assume power what Yahya did. Rather, he has already declared his intention that elections would be held as soon as October 1977, and he would return the power back to the people, and that this is just a temporary measure. And so the court then went on and saw this intervention not as somewhat of an abrogation or suspension which would attract the provisions of Article 6. They said this is an extra constitutional step which is but impelled by high considerations of state necessity and for the welfare of the people given what was about to happen. And they also put in some conditions. They said that if the situation is rather extraordinary or exceptional circumstances so warrant, that the measures taken should be proportionate to what was needed, and that if there is no other adequate remedy, and if it is only being done for a limited period of time, which was exactly what General Zia was trying to portray, this extra constitutional step was validated on the doctrine of state necessity. And apart from this, the court also went on and said that General Zia also would have the powers to amend and to make effect to any change as required in the provisions of the Constitution to get the country back in order. However, the court still held that as far as judicial review is concerned, even though the language which was given in the Laws, Continuance and Force Order stated that no CMLA order would be questioned before any court, the court said that this is a power which is inherent with us. And relying on another famous Nigerian case, they said that if the doctrine of necessity is brought into effect, any decrees, orders issued afterwards would not bar the jurisdiction of the court from hearing this case. However, in reflection, when we look back, we see that even though General Zia had intended to give away the power, this wasn't done until 1988, that is the year when his plane crashed and he lost his life. But with respect to what was already held in Asma Jilani, that a proclamation of martial law does not by itself involve the abrogation of the Constitution, what General Zia did was nonetheless yet another proclamation in a similar fashion style as that of General Yahya. So, because the basic highlight of Asma Jilani was that if a proclamation had to come into effect, it has to be done so by civilian government, and only where a situation has arisen in which the courts could no longer function. However, here, if we look back, we see that no such situation had arisen. And by the same reasoning and logic in Asma Jilani, one could argue that this was a measure which had been taken into effect without the Chief of Army Staff having actually the authority to promulgate a martial law. And apart from this, the way doctrine of necessity was pressed in service, it seems that it created an exception, because the courts didn't go up against the holding in Asma Jilani. They said that this was an exception. So if the action is undertaken by a usurper, Asma Jilani would apply, but here General Zia is not a usurper. He had actually stepped in this extra constitutional step to save the country from constitutional chaos. And since this is a limited sort of a measure only intended to last for a few months till such time that elections are held, this extra constitutional step was validated. Interestingly, again, when this question was asked, when the deadline of October had passed, the statement which was given from the government side was that till such time that public accountability as such comes full circle, again on a question as to how much time that would require, they said 6 months. So all in all, in short, this is yet another important constitutional case, the doctrine of necessity, yet again pressed into service, and this had become rather the norm for how other martial laws and proclamations were justified, something that we will cover in our certain other cases. So I'm going to cut short our lecture here today, and in our next series of lectures we will be covering some of the famous important cases under Article 58(2)(b). Thank you very much.